All right, good afternoon, everybody. How are you all feeling out there after hearing from USDA? All right, well, I'm Courtney Moran. I am founding principal of Earth Law LLC. I am also the co-founder, president, and lobbyist for the Oregon Industrial Hemp Farmers Association, and also the chief legislative strategist for Agricultural Hemp Solutions. If you don't know about some of my work, I pushed the Oregon Department of Agriculture to actually get a hemp program started here back in 2013 and 2014, which led to the first licenses being issued in 2015. And after those first 11 to 13 licensees, however you want to count them, saw how everything was playing out, we realized very quickly that we needed to organize and advocate on behalf of the industry. And so we created the Oregon Industrial Hemp Farmers Association in August of 2015, and we've been advocating for this industry and the program development here in Oregon ever since. We passed three bills to date that have created the framework for the Oregon hemp program that we know today. The work that I've done here in this state got the attention of folks in a lot of other states. I've drafted, lobbied, passed, negotiated, influenced bills in a lot of other states. I created the pilot programs in those states. I worked with Senator McConnell and Senator Wyden in drafting the Hemp Farming Act of 2018 that led to the language included in the 2018 Farm Bill that actually legalized hemp. Thank you. So I know this industry. I have been in this a long time, as long as a lot of you, and sometimes longer than some of you. And I know where we've come, I know where we are, and I know where we still need to go. But I do think that we need to take a moment to think about that. We've been in here talking about all these concerns all day, where these programs are at, and we're going to get into all that in specifics, but we have just legalized hemp. Hemp is legal after 80 years of prohibition. That's huge. And we cannot forget that. It's so important. And so we have to realize that we are at the very, very beginning of this industry. Yes, we had the pilot programs, and yes, we were doing research for the last 4.5, 5 years, but we're really at the very beginning of this industry. And that is something to remember, but also to realize how critical of a point in time and in history that we're in, and how essential it is for all of you to stay actively engaged right now, because this is really what is going to set up the framework for this industry long term, and how it's going to look for the future, and how all of you will be able to succeed or maybe not in this industry. And so it really takes every single one of us and the actions that we're taking every single day to create this industry. So please just keep that in mind. Now, I do want to begin by saying thank you to USDA. He came here because he does want to hear from all of you. They do want this crop to succeed. They are the federal agency that is supporting agriculture in this country. And, a lot of the questions that came down at the very end, I don't think he was able to convey this as clearly, is that, yes, the 2018 Farm Bill gave the regulatory authority for hemp production to the USDA. That is the authority that they were given. They have to operate within that authority. And yes, they did create rules, some of them that, Senator Wyden and I don't feel are necessarily consistent with legislative intent, but that did come down from Congress. And so some of the changes that we want to see do have to be addressed through Congress. Some of them can be addressed through the rulemaking, and we'll get into that. But it is important to understand that distinction. And it's also important, even on a state level, to understand that agencies do not lobby. They cannot lobby. They implement the regulatory framework that has been given to them in statute by either their state legislature or through Congress. So please just try to keep in mind the delineation between what agencies can do and what Congress and legislators can do. So what did the 2018 Farm Bill do? It legalized hemp. It established hemp as an agricultural commodity in the United States and gave USDA the authority to regulate commercial hemp production on a national level. It also gave state departments of agriculture and tribal governments the authority to have primary regulatory jurisdiction in their jurisdictions if they so chose by submitting a state or tribal plan for approval by the USDA. Now, again, establish it as an agricultural commodity, and that is the goal. I mean, it's right in the USDA interim final rules that they want to treat this like traditional agriculture as much as they can. And they are trying to do that, but we have to understand that theoretically under the law, anything above 0.3 THC is still a Schedule I substance. It's still considered marijuana. It's still a Schedule I substance and still regulated by the DEA. And so while we don't want to see DEA oversight anymore, and yes, that 0.3 is a completely arbitrary number, and we can get into some more of that in a little bit, that we have to understand where these different agencies are coming from. USDA has their lane, DEA has their lane, and then of course FDA has their lane when we get to the product side. And so I just want to create this general framework so when we're talking about this, you guys kind of have a more clear understanding of where these different agencies are and what they can and cannot do. So what is some of the distinctions between the 2014 Pilot Program Authority and the 2018 Farm Bill Authority? Now, Bill gave a really great presentation, but for anyone that wasn't in the room, I just want to kind of break down a few of these key pieces of the interim final rule. So number one, it is a switch from the total THC, or excuse me, the Delta-9 testing to a total THC testing standard. Labs are now required to be registered with the DEA. There is a required 15-day harvest window from the date that the sample is actually taken from the field. The sampling specifies that sampling is to be taken from flower from the top 1/3 of the plant. And that while, yes, they are trying to do representative sampling of the crop, meaning the field, again, that is of the crop in the field. It's not of the plant. We would like to see it of the plant. It's not there yet. That's what you need to start submitting comments on. And when they talk about a lot, they mean by variety. If you look at that sampling guideline, it does talk about variety, so that I know is a very big change from what we've been doing in Oregon and some other states. So I want you guys to be clear about that. Another big change is I may have already mentioned, but the DEA registered labs. But not only are DEA labs, or do labs have to be registered by the DEA, but also if the crops are non-compliant, they now have to be destroyed by a DEA authorized reversed agent. It can no longer just be destroyed by yourselves in the field. Another big change is the negligence threshold. Now, the negligence threshold was put into place in the interim final rules, and it states that if you have a crop that goes up to 0.5% THC, it will not be considered criminal or negligent up to that point, but anything above 0.5 is considered criminal negligence. It still has to be destroyed if it's between the 0.3 to 0.5, but above that 0.5 is where that criminal threshold begins. Now, as I mentioned, I did work on the drafting of the Hemp Farming Act of 2018 with Senator Wyden and Senator McConnell. And in November, Senator Wyden and Senator Merkley actually sent a letter to USDA outlining their concerns with the interim final rules, where they seek inconsistencies with legislative intent and the interim final rules. And in particular, they commented on 5 particular areas: the 15-day harvest window, the part of the crops that are being sampled, the 0.5% negligence threshold, the DEA lab requirement, and then again, the Delta-9 versus total THC requirement. Now, other congressmen and senators have also sent letters. Congressman and senator out of Indiana sent a similar letter in December, and they commented again on that 0.5 negligence threshold, on the 15-day harvest window, on the Delta-9 versus total THC testing, and specifically requested whole plant sampling. So there is a lot of push already from Congress to USDA explaining where they see inconsistencies with legislative intent and the changes that they would like to see in the rules. Now, something else that I want to explain to all of you is this transition period that we're in right now. Now, Bill explained that so far there have been several tribal plans that have been approved, 6 state plans that have been approved, and so I think and that Oregon, yes, has not yet submitted a plan. Washington has submitted a plan. It's not yet been approved. But I think it's important to understand what this transition period means and what compliance means for where you're at. So right now, this transition period started on October 31st of 2019, where states and tribal governments are starting to submit these plans, starting to have them approved, and this 1-year transition period ends October 31st of 2020. So during this 1 year, there are 3 options for compliance depending on what jurisdiction that you're in. The first is compliance with that 2018 Farm Bill if you are in a jurisdiction that already has a state or tribal government plan approved. And so it's those 7 tribal governments and those 6 states so far. The second option is to be directly regulated by USDA under the 2018 Farm Bill if your state or tribal government has elected to be regulated as such. For example, Maryland has elected to be regulated directly by USDA. The third option is to remain under the 2014 pilot program. And that is what actually 9 states have specifically stated to USA that they will remain under the 2014 pilot program. It includes Colorado. Oregon has not yet submitted a plan. And actually just last week, Kentucky told the USDA that they will not be submitting a plan under the interim final rules because they are so concerned with the provisions that are contained in there. In specific, I know that they are very concerned about the sampling requirements and the THC threshold because they have allowed a variance up to 0.39 to date in their program. There are other concerns that they have, but they have particularly highlighted those. So I think this speaks very, very loudly to USDA, to DEA, and to Congress, that the states that have been approved so far are states that really have not done very much for the industry. They haven't really pushed their programs. Some of them never really had programs. And the states that have done a lot, that have been growing from the beginning and really pushing the policy for the industry, they have not submitted plans. I think that's really, really key, a really key message. And also important for the farmers and industry participants in those jurisdictions to realize that your states are doing everything they can to protect you, given the regulatory framework that is out there. And so in Oregon, yes, we have not yet submitted a state plan. I'm going to get into very specific details about what's happening here in Oregon, but you should know that all the conversations that I do have with USDA and with Oregon Department of Agriculture and other departments of agriculture, they do want you to succeed. And, you know, we are working against overcoming these 80 years of prohibition fear, the confusion with law enforcement, the transition into a legal and regulated market. And so it's going to take time, it's going to take education, and it's going to take all of us to be patient, but to be actively engaged. So just this last week, actually, or 1 week ago, Tuesday, the American Farm Bureau Federation actually updated their overall policy on hemp and put some pretty bold things in there, which is really amazing and going to be very helpful for all of us. I know Bill actually mentioned this during his presentation, that they have submitted comments and that Farm Bureau has a very big influence in DC. And I'm going to point out some of these different changes that were made into the Farm Bureau policy. They have specifically stated that they support the production, processing, commercialization, and utilization of hemp, and that it be regulated by USDA rather than the DEA. They have specifically called out that the changes to the 2018 Farm Bill that allow for industrial hemp with up to 1% to be legal. So American Farm Bureau does want to see this 1% threshold changed. They request testing of the whole plant. They say that non-CBD hemp should be exempted from the DEA testing lab requirements. They want alternative uses and non-consumable uses as a disposal method for hot crops, other than the DEA disposal rules. That products derived from legal hemp should be afforded the same status as legal hemp. And that uniform standards for transportation and sale of CBD products and seed and interstate commerce should be put in place. So there is a lot of discussion nationally to secure these changes that I know that we all want to see. But it's not just going to happen. It's going to take every single one of us to take action to make these changes happen. And so you have an opportunity today, literally until 8:59 p.m. today, to submit comments to the USDA. And if you haven't, you need to, because if you're not submitting comments, then they don't know what your concerns are, and they don't know what you're looking for. And like Bill said, just saying that this isn't working for me or I'm unhappy, that's not helpful. They can't do anything with that. But what they need data, they need facts, they need evidence, they need your COAs, they need information about how much did this cost you, how many laborers did you have, how many days did it actually take for you to get your test results back from the testing labs, and information like that. You know, they want to know exactly how everything here affects you. And so my Farmers Association, OIHFA, we have actually put together a one-page form that you can fill out that outlines these specific questions and information that USDA is looking for. I have several copies up here. If you fill this out, I will submit it for you today. Okay? I'm leaving here at 4 p.m., so you will have to do this right after my presentation. It will take you 5 minutes. If you want to email them to me, I guess by 7 o'clock tonight, I will still submit them for you. But please, this is what we have to do. And now, a gentleman at the last panel asked a question about, are you even listening? Are you advocating? If these issues with the 0.3% need to be directed to Congress, why would I submit a comment to USDA? And it's exactly what Bill said, because when you submit these comments, they are on the record. And it's not just for USDA. Congress can see these. Anyone in the public can see these. DEA can see these. This is huge. And this is what protects any issues that we have in the future if there ever is going to be litigation on these types of rules and what's happening with the program. You have to secure your right and secure your standing now if you want to question and potentially litigate these issues. And so you need to submit comments. But what's also important is that advocacy cannot stop today. Just because the comment period is over doesn't mean this fight is over. And yes, the fight's on the federal level, but this is all going to play out in your fields and in your facilities. And so you have got to pay attention and you have got to be engaged. And so to address these issues, I have launched a federal lobbying campaign through my federal lobbying firm, Agricultural Hemp Solutions. The campaign is specifically to address these issues with the interim final rules, and it is also to lobby Congress to change the definition of hemp to get to a 1% THC definition. Thank you. That is the science. People are constantly asking, where did this 0.3 come from? It came from a study in 1976 by Ernest Small. And in there, he clarifies that at the 0.3, that there is no potential for intoxication. Unfortunately, that one clause got carried out and was policy set in Canada, policy set in the EU, and now policy that's been set in the United States. But several other studies that he has published talk very clearly about the 1% threshold for intoxication, and that is what we are striving for. And I can tell you that when I was in, DC negotiating the 2018 Farm Bill language, I had almost every office agree up to the 1%. Mitch McConnell's office was not supportive of the 1%. There is still a lot of fear, reefer madness fear. There's a lot of fear about cannabis. There's a lot of fear about intoxication out there. And so, we have to be very responsible about what we're doing every day, about the products that we're putting on the market. We cannot be feeding their fear by putting dangerous products on the market. We need to be conscious about what we're doing, and by providing them evidence and showing that we are a responsible industry is the only way that we can get there. So I encourage you all to join this federal lobbying campaign. It is not going to be done without your support. And so you can talk to me after. You can reach out to me, Courtney at Agricultural Hemp Solutions. Just check out agriculturalhempsolutions.com to learn more about the campaign and how you can get involved. And that is what we need to be focusing on a federal level. So what's happening in Oregon, and how is this all going to be playing out here? Well, I don't know if any of you were in the talk this morning. I thought Sunny did a really fabulous job of kind of laying out about where Oregon is and what the plan is for this upcoming year. So as she mentioned, that Oregon has not yet submitted a state plan. Part of the reason is, one, that they want to continue to protect you under the 2014 Farm Bill as long as that they possibly can, but also that ODA does need specific legislative authority to actually submit a state plan to the USDA, and in particular, they need authority for a criminal records check. So as is required by the 2018 Farm Bill, anyone who is not in the pilot program is subject to a criminal records check, and if they have a controlled substances felony within the last 10 years, they are not eligible to participate in the program for 10 years. So that is a particular requirement that, we have not required any sort of background checks or criminal records checks in our program to date, and that is authority that we do have to give to ODA. Now, that is something that the Oregon Industrial Hemp Farmers Association is working on. We have 2 bills that we are working on this session, and I will get to those in a moment, but I want to take a step back about this transition period that I mentioned. So like I said, we have not submitted a state plan, so Oregon is still operating under the 2014 Farm Bill. What does that mean? That we have protections under our current rules of the program. And now, yes, ODA did switch to a total THC testing standard as of January 1st for pre-harvest. But that is the only thing that has changed. Nothing else has changed. And I get a lot of questions lately about, is my crop illegal now? What can I do? I mean, the gentleman in the last panel actually asked that as well. And your 2014 crops are protected under the 2014 authority. But what you do need to understand, and Bill did lay this out from a federal perspective, that now that we're in this transition period, there are different regulations in every single state. And, yes, well, you go on that interstate transport. If you were under the 2014 Farm Bill, it is protected under the 2014 Farm Bill. But as soon as it lands in that jurisdiction, your crop or your product need to be compliant with those jurisdictions' regulations. That is very important. There is no guarantee that just because it was lawful here in Oregon, it's going to be lawful somewhere else. So you need to be paying attention to what those rules are to wherever you're shipping your material to. The other thing is that in Oregon in 2018, in the marijuana statutes, it was made a crime to actually import or export or to sell direct to a consumer any hemp above 0.3 total THC. Okay, this is not new. This has been in place since 2018. Now, this is not to be confused with the testing requirements here for end products. Testing requirements for end products was established back in 2016 to protect public and consumer safety. While yes, they are now tied together, they were not put in law together. They did not have the same intent, and they were done through completely different statutes. So you have to understand that the end product testing requirement is not tied to that criminal liability, but that criminal liability was established separately, and it was established back in 2018. That was not a change as of January 1st. So what are we doing here in Oregon to work on these issues? So this session, the Oregon Industrial Hemp Farmers Association is working on two pieces of legislation. The first is the Oregon Hemp State Program Bill, House Bill 4072. This bill is in particular to give ODA that authority to submit a state plan to to the U.S. Department of Agriculture, to give them authority to do criminal records checks, gives them overall additional rulemaking authority over the program. We are no longer defining industrial hemp as industrial hemp. We're going to be defining it as hemp, and we're actually moving the definition to rule. So it will no longer be defined in statute. It will be defined in the ODA rules. We are also updating it from registrations to licenses. This is more of a change in name than any effect, but just so you know that next year it will be a license. And we're doing a couple other minor changes. But one of the biggest changes that I am pushing for is to change that criminal threshold from the 0.3 total THC to 1% total THC. Now, this bill, when it passes, it will go into effect October 31st of 2020. So it's not going to do anything immediately, but it would go into effect October 31st of 2020. Now, this is a short session. We have 35 days to get these bills passed, but I have included this language in this bill because this bill has to pass. If this bill doesn't pass, that means our regulatory authority goes from ODA to USDA. And everyone in the legislature knows that that cannot happen. We have worked way too hard over the past several years to create the program that we have created today. We have 5 chief sponsors on this bill. This is the most I have ever seen on a bill. We have incredible support in the Capitol. But you also have to understand that despite having all the support and knowing that we have to pass this bill, there is a lot of concern from law enforcement about what has been happening in this industry and in the overall cannabis industries in this state. And both Sunny talked about this morning as well as Steve Marks in his panel, is that there is a lot of concern from law enforcement about being able to tell, is this a lawful hemp shipment or is this an illegal marijuana shipment that's being disguised as hemp? And it's been a huge problem. And law enforcement is looking to create a tracking and tagging system on all hemp shipments. Now, they want to see you tracked just like the recreational cannabis market, OLCC metric tracking. We are advocating against that, but they are looking to do something that right now they're calling a commercial cannabis shipping tags, things like that. We are working against this, but this is something that we are up against and that you need to be aware of that could be coming down the pipeline sometime, whether it's this year or next year. There eventually will be some sort of regulation on your shipping to help with law enforcement. And this can actually be a good thing both ways. We've been very clear with them, this cannot be cost prohibitive. This has to be something easy and simple for the farmers. But how many of you have had seizures? I know that I have a lot of clients that have had seizures or that have been pulled over by law enforcement. I've been able to get every single one of them back, thankfully. I can't say that for every attorney that I know, but I know that all of you are dealing with this. And so if we create this dialogue with law enforcement and are able to engage with them and figure out a system that can work for all of us, it can be mutually beneficial to help maintain the compliance of our program. Now, the other bill that we are working on is the Hemp Commodity Commission bill. I believe that's House Bill 4051. Now, the Hemp Commodity Commission is something that we've been working on for several years. This is going to be an incredible benefit to the Oregon industry. It does levy up to a 2% assessment on the crop at the farm gate, but this funding will go toward research and international marketing of the crop. It will provide funding for farming best practices, issues with coexistence and cross-pollination, and will also, like I said, help with the marketing of your crops and getting the word out about your crops and your products internationally. It will allow funding for the recently established Global Hemp Innovation Center at Oregon State University, which is being led by Dr. Jay Noller. He's an internationally renowned expert researcher on hemp. If you don't know him, we are so lucky to have him in our state and to be very supportive of the work that we're doing. So if you would like to learn more about the legislation, what's being done in state, I would encourage you to become members of the Oregon Industrial Hemp Farmers Association. We are working on all this legislation, all of the rulemaking, all of these questions that have been coming up about, is my crop legal, is it not, compliance issues. I can tell you all of the members don't have those questions because they have been informed as this policy is being put into place, and they know what's happening beforehand. It wasn't a surprise that these rules are changing, or that, they're not thinking, hey, everything's illegal now the 1st of January, because they have been involved and engaged and have been working with us on this policy development. So if you would like to stay up to date and informed, I would encourage that you become a member. Session starts on Monday, and so this is all going to be coming down right now. So I would really encourage you to get involved on both the state and a federal level. Does anybody have any questions? Oh, please go to the microphone, sorry. Yeah.
Oh, you go.
Oh, man.
I need a second. I thought I knew what I was going to say.
Okay. So I'm completely confused, maybe.
Okay.
So you just mentioned that, so Oregon is still running on the 2014,
Yes.
which is Delta 9, but as of January 1st, it's total. And is that now 2020 crops is going to be total? Now I'm talking biomass, right? So your pre-harvest test is tested at lower than 0.3. Your post-harvest non-detect Delta 9 higher than 0.3. So do you just now sell that as biomass, isolate, or distillate? Can I ship it to a Delta 9 state? I mean, there's so much confusion even from here from experts. Am I legal with a Delta 9
Okay, so
for 2019 harvest?
Yes, 2019 harvest, pre-harvest, Delta 9, compliant.
Right. But post-harvest is higher than...
Post-harvest is tested at total THC.
Okay.
Has been the case since 2018. There is a criminal restriction on importing or exporting or selling directly to a consumer anything above 0.3 total THC.
To anybody or to consumers?
Directly
sell
to a
to a
consumer. You can
processor?
sell to handlers, you can sell to secondary handlers, you can sell to OLCC processors.
Over for Delta 9.
And you
if
can
I'm
sell to
over-
OLCC retailers anything over 0.3 total. Yes. So
Okay.
in-state, you can do any transfers between manufacturers. The only restrictions are that import and export and direct to a consumer. And that was all done in the marijuana statutes. I've been fighting against it ever since. And I have language in the bill right now. I can make no guarantees this is going to pass, but it's there.
Okay, so my question is a follow-up on that. You just said 0.3%. Above 0.3% can be sold to OLCC retail? What?
Yep,
How?
that was put in place in 2017
Okay.
in legislation.
Does the hemp certificate exist?
It does exist. There are several folks that have the hemp certificate.
Who's got one?
It's only $1,000.
She's got one. Okay, so we thought that this loophole existed, that between 0.3 and 1%, there's got to be somewhere, and we've got to be able to take it into the OLCC retail. There was an entire presentation on it, and we didn't talk about it.
I noticed that. I was wondering if the OLCC
Like
was
what?
going to mention
How
it.
did we end up
All right,
talking about
let me
interstate marijuana
clarify
transport?
that real quick. Okay, so in Senate Bill 1015 in 2017, we created the authority for hemp growers and handlers to transfer to OLCC processors. In 2018, in House Bill 4089, we created the authority for any hemp grower or hemp handler who got a hemp certificate from OLCC to transfer into any licensee to OLCC. So if you're a registered hemp grower or hemp handler that has this OLCC hemp certificate, you can sell to an OLCC processor, wholesaler, or retailer.
So we just
Dispensary
have
owner.
to get the certificate.
You just have to get the hemp certificate. You have to comply with the same testing, labeling, and packaging requirements as OLCC. So
Does
it
that mean
is still
seed to
those
sale?
15-pound batch testing.
Does that mean seed to sale?
No. From the moment that you decide that it's going to OLCC, that's when it begins being tracked through Metric. You get your hemp certificate, put it into Metric, take it to a lab, then it goes to OLCC. Once it's in OLCC, it cannot come out.
Okay.
The thresholds for OLCC, up to 1% THC for usable flower, usable hemp. You can sell up to 5% THC of concentrates.
Oh my God, thank you.
You're welcome.
That is the most useful thing I've heard. Thank you.
Yeah. That's it. You're all good? All right, so just as a recap, please submit comments to USDA. If you haven't, please fill this form out. I will submit them for you. Please get involved. I would really encourage it. You know, everything that you guys are doing every single day matters. We want to hear from you. We want you to all be engaged. We want to help you. We are here. The greater our numbers, the louder our voice. So please get engaged. You have a question?
Yeah, real quick on when you said it needs to be under the 0.3% for direct to consumer, but anything below them is totally fine to retail. You can go into retail with over 0.3 total THC.
By retail, you mean OLCC?
No, you were saying that it's only illegal.
So direct to consumer, a retailer that's selling direct to a consumer, you could transfer it to them, but then if they sell it, then they're going to be committing a crime.
Right. So, okay, that clears that up. So, and then when you said import or export, is that through state line or out of the country?
Anything leaving the lines of the state. So
okay.
if you leave the line
Yeah.
of the state and you're going to another country, you've still left the line of the
Still
state.
has to be 0.3.
Total.
Got it. Thank
Yep.
you.
So in dealing with IRS, the 280E, I have been asked a lot of questions about having a CBD separated area from a THC for sales. And this is obviously because they want to separate your different expenses. In Oregon, what you just said is that if you have more than 0.3 and you enter it into, I'm understanding this, I'm not saying this is, this is more like correct me. And you have your certificate and you enter it into Metrics and you sell to an OLCC dispensary, right? Then you can sell that portion that would, I guess most people are just calling this the hot stuff, right? And you can sell that. What part are you not allowed? What CBD? Is it below 0.3 then you're not allowed to sell within that dispensary?
You can sell anything you want to into the OLCC up to their concentration thresholds if you have that hemp certificate and you're going through, you know, the testing, labeling, packaging, etc. So 0% to 1% total THC for usable hemp. 0% to 5% for concentrates. They have it broken out for every single one. I just don't know them off the top of my head.
Okay, so from the viewpoint of the OLCC, if you had half of your store on the right was just CBD below 0.3, so it's below the federal limit, right? And the other half had THC and above 0.3 and whatever, wherever it goes from there, from both hemp and from regular THC growers, that would be all right within a dispensary. Is that correct?
So it would be one store, one licensed facility. They don't split up the stores. You can have CBD products in there.
Okay.
If they are derived from hemp, they have to be labeled that they're derived from hemp and that they're not derived from marijuana. To have
right.
particular labeling requirements.
Okay. Thank you very much.
Probably like fourth and fifth follow-up on the same question. Apologize.
It's okay.
The specific language for exporting out of Oregon, is that export only apply to a direct customer out of state, or is it just the fact it's leaving the state?
Anything leaving the state is an
Okay.
export.
And then on these hemp certificates with OLCC, are they still issuing those, or has that window closed?
I am not sure about that.
I just heard rumor they were closed. So you just can't, okay. So it's not like we can all get one of those now. So we understand it. Okay, thanks.
Not sure.
Okay.
They're out there.
Maybe on that question, I was going to ask, will those OLCC hemp certificates basically be invalid in next year after October 31st? Will everyone be forced to
No.
grow under 0.3? Okay.
No. So you need to keep in mind that the USDA interim final rules are only covering what happens to the moment of harvest. The second that crop is out, USDA's hands are off for now. All right, that's when either your state or FDA gets involved with what you're doing. And so you need to be paying attention to the rules in Oregon. We have done a lot of things for what you can do post-harvest that most other states aren't even talking about. I mean, there's a lot of states you can't even have flower or possess it, and look what we're doing.
All right, thank you.
All right, last question. We're getting the lights flickered.
I just wanted to clarify and ask if it's your understanding, just because I think it might not have been exactly obvious with the last questions with Oregon standards on the 0.3. Is it your understanding that pre-harvest tests always have to be 0.3 currently under Oregon standards, but after that point, if it goes above 0.3, then it can go to the OLCC. And not that if the pre-harvest test is above 0.3.
Yes, pre-harvest
Great,
always has to be at the 0.3. If it's not, then it is not hemp and it is illegal marijuana. So under the 2019 season and before that, it was all the Delta 9, right? But now for 2020, pre-harvest has to be at 0.3 total THC. If it is not, it is illegal marijuana and has to be destroyed.
Great, that is also my understanding. I just wanted to clarify
Yep.
because we weren't distinguishing. Thank
Yep.
you.
All right, good luck, everybody. Get involved. OregonHempFarmers.com, agriculturalhempsolutions.com.